Tyler Brown up next from the Bryant Law Center in Paducah, Mayfield, and Louisville, taking questions regarding criminal defense. And someone has a question that says, can I be charged with DUI for riding a bicycle under the influence since it's a non-motorized vehicle?
Okay, Dave, yeah, that's a good question. Most states will have statutes on point that are going to cover that situation. So in general, no. You can be charged with a DUI for operating a bicycle, even though technically it doesn't have a motor. It's not a motorized vehicle. In the Commonwealth of Kentucky, there's a statute that's directly on point. It's KRS 189-520 that does cover operating under the influence of a non-motorized vehicle, including like a bicycle. And that statute lays out the standards, which are pretty much exactly the same as the DUI standards for a motorized vehicle. So I do believe most states are going to have something on point that's going to cover that. And also, it's, you know, just as a general rule of thumb, operating any kind of vehicle, whether it's motorized or not, while you're under the influence is going to be dangerous. It's just a risk that's not worth taking.
Next question sent in from someone who says, my sister has a substance abuse addiction and her husband has expressed concerns to me that she's putting herself and her family at risk of danger. Is there any way we can make her legally obligated to get treatment for the sake of herself and her family?
And Dave, yes, there is. Many states, I think most states have adopted what's generally referred to as Casey's Law. I know we have here in the Commonwealth of Kentucky. And what Casey's Law does is allow a family member, friend, spouse, parent to be able to petition the court to have somebody subjected to drug and alcohol treatment if it's necessary. And what will happen is once you file that petition, the court's going to have that person assessed by some medical experts to determine whether or not they could benefit from treatment. And if so, then the court can order them to participate in that treatment. And then there's contempt powers if a person fails to do that or refuses to go to treatment. It wouldn't be a criminal violation per se to ignore the court's orders, but the court could potentially hold somebody in custody until they are in compliance with the court order. These petitions can be filed through the county attorney's office on your own, but I do recommend, I think it's helpful to have your own attorney if you're a family member seeking to file that petition to help you get it in order. Coordinate with the county attorney's office. We're more than happy to help in those situations, but yes, there is a solution short of a criminal violation that can help folks in need with substance abuse problems.
Got time for one last quick question. Someone wants to know, if I recently had an expungement, am I still obligated to tell a landlord that I have a past criminal record on my apartment housing application? Got about 30 seconds here, Tyler.
In short, if you look at the statutes in Kentucky, they're pretty clear as far as once you've successfully expunged a criminal charge, the effect of that is basically that it had never existed and you were not required to acknowledge that in any application or any form. So if you want to make sure, talk to an attorney to go through the expungement process and confirm absolutely that the expungement's been granted. Once that's been completed, there will be no record of it and you will not be required to acknowledge that.
Tyler Brown from the Bryant Law Center, our guest today on part 2 of Local 6 Legal Line. And just like that, our time is gone. More questions in the pipeline. I'm sorry we don't have time to get to those. But meanwhile, if you'd like to review either one of these segments we've had today, give us a little time. We'll post it online at WPSTlocal6.com.